That's something else. The city of Huntington Woods and Pleasant Ridge versus Oak Park and 45th District Court. Each side has 15 minutes. Quite a bit of passing of the guard.
Good afternoon. Mark Ronzato on behalf of the plaintiffs, appellants in this case. To the extent there's any self-imposed limitations on questions, I waive that. We are here on a question of district court funding. I'm going to spend hopefully my limited time here speaking about two distinct but interrelated issues with respect to district court funding. The question, fundamental question that the court has asked, the first question that the court has asked for, involves the responsibility of two municipalities and a township whose case has been stayed at the present time, with respect to a district court that does not sit within their jurisdiction. The question in this case is not whether my clients have a funding responsibility for the 45th District Court. They do. In the 41 years, I believe, that the 45th District Court has been in existence, my clients have contributed millions of dollars to the operation of that court. They have done so in the manner prescribed by the Michigan legislature in MCL 600.8379. That's the statute that said once my clients opted not to house the district court within their jurisdictions, that every ticket issued in the two cities whom I represent, every ticket issued, 2/3 of the proceeds from that ticket would go to the city of Oak Park. And the question, therefore, is not whether my clients have an obligation to fund the district court. The question becomes, as the court put it in its order that brings us here today, whether we have an independent obligation to fund the district court. I think it is very safe to say that the Michigan Court of Appeals decision in this case with respect to the two competing statutes sort of lacked subtlety. It didn't quite grasp the difficulty presented by the position that the defendants have advocated and been successful in advocating up to this point. Because what exists in this unique, it seems to me, situation is that as of 1970, the Michigan legislature passed two statutes, not just one, 8103 and 8104. But 8104 particularly says in the strongest language possible that in this particular situation, that is a district court housed outside the jurisdiction of my clients, in that situation, my clients shall not have any financial responsibility for the operation of the court except as provided in this act. Now, what has happened in this case is the defendants have relied upon a statute that was written, I believe, 26 years later, in 1996, and they have suggested that that statute, 8271, MCL 600.8271, means that my clients will always have an independent of 8379, an independent obligation. So we have a general statute which says, and it's bolstered by its preceding statute, 8103 and 8104, which says my clients never, ever have an independent obligation. And I have a Court of Appeals decision that says, on the basis of another statute, that my clients always have an independent obligation.
Mr. Gonzato, can I interrupt you? May I interrupt you?
You certainly may.
I think I may. So going back to what you started with, the 8379 money, the 8379 money, I couldn't find anything in the record to figure out how to think about what portion of the cost of processing your client's tickets
Yes.
is covered by, from what I could tell, maybe they're getting rich off the 8379 monies, or maybe it's covering very little of the marginal cost of doing whatever extra number of tickets they have to do in Oak Park because of the miscreants in Pleasant Ridge and Huntington Woods. I know there aren't a lot, but there are some. And I don't know what the marginal cost of doing that extra business is, and I don't know what portion of it is covered by those 8379 fees. Maybe your answer is doesn't matter, I shouldn't be thinking about it, because you have this plain language argument, and we like those. But it did come out in your pleadings back and forth that your view is we're already covering what we have to cover. Does it matter to me that we don't know what the answer to what an economist would say about how those numbers come out?
I must tell you, and I'm sure I will be followed up by my opponents here, there was something in the responses or the material submitted with in response to the motion for summary disposition with respect to the financial plight of the 45th District Court. As I've indicated in my brief, that's irrelevant here. We are dealing with statutes, trying to piece together two statutes. But I will tell you that there was definitely no discovery done with respect to the representations that have been made as to the financial impecunity of the District Court. Nothing. All that's been submitted.
But this was a C-10 motion. But this was a C-10 motion.
That's correct. It was filed, though, before discovery was completed.
Okay.
Okay. Now, I will grant you, and you'll probably hear, there were documents attached to suggest that the District Court had financial difficulty. There was no discovery conducted on that point.
Financial difficulty doesn't answer my question. You might have financial difficulty just because, for lots of reasons. I'm interested in what portion of the financial difficulty is specifically related to doing the cost of business of your client's tickets that isn't covered by the bonanza they get in the 2/3, 1/3 sharing under 8379.
Well, I don't know if I fully understand your question.
Well, I don't know if I do either.
I thought it was a good question.
Okay. But
Look,
the bottom line.
I'm trying to figure out whether the scheme, the 2/3, 1/3, it was designed to cover the cost of maintaining a court for the benefit of people outside its political boundaries.
Or is it close enough? Is it
Well,
it doesn't?
this is the fundamental question presented in this
Let me
case.
give another bit of the puzzle here, that prior to the 1970 amendment, there was an explicit population proportional allocation required.
And you're exactly right.
That disappeared.
That
Let me
disappeared.
ask the question, because I don't remember. Was the 2/3, 1/3 a part of the statutory scheme when the population proportional?
And I believe that they came together, the 70 change, because
so they
8104 was 180 degrees different in 1970. Prior to 1970, it said that my clients had a responsibility for the entire district court. In 1970, 8104-2 was enacted, which said they shall not be responsible.
No, I thought there was a provision that required, according to the portion of the population of the cities that were not, where if there was a multi-district court, the municipalities, other than the one where the court sat, had a responsibility according to their population to contribute. Is that not right?
Well, I'll read you the prior statutory language from 8104. And in the same proportion as the population of the district control unit bears to the population of all district control units within the district. So that was, in fact, the proportion, and
Right.
that was eliminated.
Right, okay. Well, I thought you were disputing the fact that there was a population-based contribution under the pre-70 change.
There was. There was a population-based, but it was a contribution to the entire district court. What they replaced it with in 1970 is a statutory amendment which said, my clients shall not be responsible for any financial obligations to the district court, except as provided in this act.
Except as in 8379. Right.
8379 is one such exception.
8379, was that part of the pre-70 regime as well?
I believe it was passed at the same time. There was a CL 1970.
So we dropped the population formula for the 1/3, 2/3.
And that's the way it went, I believe, in the Michigan legislature.
I think that's right, but I'll
okay.
perhaps.
But the point is that what the Court of Appeals has done in this case is taken the except language that concludes 8104(2) and used 8271, which means that the general rule, if the Court of Appeals right, will never be applied. What the Court of Appeals has set up is a system in which the Michigan legislature has made it crystal clear this is the general rule. That general rule, if the Court of Appeals is correct, will never, ever hold. It will never be applied because it has been overwhelmed by this statute, which, in my estimation, and I hope yours, is not a funding statute. It is an appropriation statute. It describes the mechanism by which money that is owed to the district court is to be appropriated. But consider this as well, another point to be made here. The except language of 8104(2) says except as provided in MCL 600.8621(1). Now, 8621(1) is important for purposes of interpretation here, because that's a statute that says that every unit, every governmental unit involved in a multi-district court, has an obligation to fund court reporting services. My clients have an independent obligation to fund court reporting services. Now, there are two important points that seems to be drawn from that reservation, that limitation on in 8104(2). Number one, the fact is that we have to concede that my clients do have a very limited independent obligation to fund the district court. Why? Because we have an independent obligation to fund district court reporting services. That's in the statute. But what's also important in terms of the interpretation of these two major statutes that the Court of Appeals was involved in is, if the Court of Appeals is right, why does the reference to 8161 have to be there? It doesn't have to be there, because what the Court of Appeals has found is that there's an overarching obligation on the part of my clients to pay for all of the operation of the district court. I'm sorry?
Do you wish to reserve any time?
Do you want to reserve any time?
Yeah.
He likes to speak quietly to waste your time. I'm just kidding.
Sit down.
You've got 2 minutes, 45 seconds.
Okay, I'll sit down.
I thought I was using my outside voice.
You're so genteel.
Good afternoon. If the court please, Bill Hampton, together with Nancy Cooper Green, appearing on behalf of the City of Oak Park Appalese. Mr. Webster, who represents the district court, and I have agreed to split our 15 minutes.
You can try.
I will try to adhere to the 7.5 minutes that I have allotted to me, and I assure you, Mr. Chief Justice, there will be no duplication. I want to start because I think Justice McCormick hit the nail right on the head on what is happening in this particular case. When the court collects 2/3 of the ticket revenue from the 3 appellate communities, and they collect 100% of the ticket revenue from the City of Oak Park, there is a shortfall. That shortfall is approximately $200,000 a year.
Is that fact in the record somewhere?
Yes. In fact, there is an Exhibit 4 in the record, Justice, that over a 6-year period, the City of Oak Park, out of its general fund, has expended over $900,000 in order to meet the budget of the court. In addition to that, the city of Oak Park, because it owns the building that houses the court, gives the court free rent, free utilities, free payroll services, free IT services, and I could go on and on. The bottom line is this simply cannot continue because there is no agreement that Oak Park will supplement the budget. And what we're asking for and what the Court of Appeals agreed is under 8271, the appellant communities have an independent obligation to make up the shortfall. There's nothing in the 2/3, 1/3 statute that limits the obligation of the appellant communities to contributing the 2/3. There's nothing in the statute to draw that implication. And I think the important thing to recognize here is we have basically 4 statutes that deal with the subject matter, and those are set forth in the brief. All of those statutes except one state, except as otherwise provided in this act. In fact, the statute that Mr. Granzato relies upon, 81042, and he just read part of it where he said except as provided in 8621, he left out the statement and other provisions of this act. So when you look at all of the applicable statutes, and the fact has to be made that you have to read all of these statutes in conformity with one another to make all of them common sense. All of them say except as otherwise provided in this act, except 8271.
I'm not sure the Court of Appeals read them in conformity with themselves, much less in.
Well, I'm not sure.
Let me just get to the point. I don't understand how 8271 otherwise provides when it states that, quote, the governing body of each district funding unit shall annually appropriate by line or lump sum funds for the operation of the district court in that district. Why doesn't the term in that district have the same limiting interpretation as it does in 81033 and 81042, which are express limitations that say you don't have to fund anybody outside your political district?
Well, if I understand the court correctly, again, I would go back to say that in both 8103 and 8104, it contains the language except as otherwise provided in this act, and 8271 states that the governing body of each district funding unit shall, not may, shall annually appropriate the budget funds for the operation of the court in that district. Now, 8104 defines...
What does in that district mean in 8271?
Well, in that district means what 8104 parent 1 says, that the definition of a district funding unit is any city or township in a third class of the third class. So that means when it says in 8271 in that district, that means all of the appellant communities plus the city of Oak Park. And again, the language is mandatory.
But that's what I'm having difficulty.
Okay.
You're trying to, or at least the Court of Appeals read in that district as 45th district, as opposed to the Pleasant Ridge district or the Huntington Woods district, right?
Are you asking me about the definition of what a district is?
Yeah.
I think it's very clear. A district includes all of the communities that make up the 45th District Court.
Is that what you read in 8103 and 8104 as well?
Yes. I think, like I said, if you read all 4 statutes together, 8271 trumps all of the other statutes. I think that's very clear.
Well, either they're harmonious or they're not. They use the same term, in this district. Do they all mean this, when they say in this district, do they all mean the same thing? Or they only mean the same thing in 8103 and 8104, but something different in 8271? Are they all the same, or does, when it's used in 8271 in that district mean something different?
I think when the word district is used in all of those statutes, it means one and the same. If I may,
So wait a minute, I'm sorry.
I'm sorry.
I'm sorry, no.
That's all right.
You can't leave, because now, if your interpretation of in that district means 45th district, then 8103 and 8104 do not place a limit on the obligation of Huntington Woods and Pleasant Ridge to fund the court.
Do not place an obligation?
Do not restrict, or they create an obligation. No, let me state it correctly.
Well,
Wait a minute, 8103 and 8104 have been read, I believe, to say that there is no obligation to fund a court outside of the political boundary of the municipality. Is that your understanding of how those
yes.
are read? You're saying, I believe, that's an incorrect reading. They should be read as applying to the 45th District Court, not their political boundaries.
That's right, and I would go back also, Mr. Chief Justice, to 8379, the 2/3, 1/3. If that was intended to be the exclusive obligation of the appellant communities, the statute would have said that. And it doesn't say that at all. It doesn't limit their obligation to meet the funding obligation of the court merely by putting in their 2/3. And going back to what Justice McCormick pointed out, that doesn't meet the budget. How in the world can the city of Oak Park assume this massive obligation to fund the court just because the appellant communities adopted a resolution saying they don't want the court in their jurisdiction? And then the legislative enactments that I pointed out do not lead to the ultimate conclusion that therefore, since Oak Park ended up because the court was in their jurisdiction, that they have to make up this massive shortfall in the budget. I know my time is up, and I just want to say because I don't want to go into Mr. Webster's time, I want to indicate to the court what I'm asking the court to do. I'm asking the court to issue a peremptory order that would require the cities of Huntington Woods and Pleasant Ridge to reimburse the portion of the fees collected for the building operation and retiree benefits. Those are the two funds that are subject in this case. From July 1, 2012 to February 12, 2014, to the appropriate fund for use in the manner in which the fees were assessed and collected. And secondly, and finally, I'm asking the court to issue a peremptory order that, pursuant to MCR 8.201, deals with allocation of costs in a third-class district, that shall be implemented immediately in the 45th District Court until such time as a valid expense-sharing agreement is entered into between the district funding units in accordance with 81043. Because there never has been an agreement entered into, and if there was an agreement to be entered into along the lines of other districts of the third class that I have seen, the way this is generally handled in other third-class districts is that the shortfall, in my example, is handled according to, it's apportioned according to case load. And therefore, under the current situation, if such an agreement were allocated according to caseload here, the Oak Park would pick up 64% of the shortfall, and the appellant communities would pick up the balance of that shortfall based upon their caseload. Thank you very much for your time. Appreciate it.
Good afternoon, Your Honors. Peter Webster from Dickinson, right on behalf of the 45th District Court. I know profoundly now the meaning of chomping at the bit.
Can your client decline to process cases from Huntington Woods and Pleasant Ridge if they aren't compensated?
No.
I know you're chomping at the bit, but is going back to Justice McCormick's question earlier, we have 6 years where there's been a shortfall. Would I be wrong to conclude that it seems to me this whole funding structure is such that the time when the agreement's supposed to be struck is when Oak Park decides to host the district court. That's when you sort of make this agreement back in the 70s, but no agreement apparently was made back then, and so it seems like there wasn't that big of an issue, at least if there was, we never heard about it for all these decades. But then we have a recession in Michigan and ticket revenues go down, and then all of a sudden there's a shortfall. And is that what lands this case on our doorstep?
Actually, the record shows that there's been a historical shortfall, for example, going back at least to 1983. So what actually precipitated this in particular was a reorganization attempt, first to reorganize the district court by the legislature. Ultimately, that did not originally go through, and then the new reorganization which went through, which established actually the 45th District Court in 2012, 681-23-4 establishes a 45th District Court. The district is comprised of the cities and Royal Oak Township. My point here is, I wanted to make real quickly, it is a fundamental misrepresentation to argue that 8379 addresses funding obligation. 8379 is a revenue share distribution obligation. To illustrate that, suppose that the revenues, or everyone drove really well within the district, revenues are zero, there's still an obligation to fund the court.
There's a need, but there isn't
That's the
necessarily
question.
an
I mean,
obligation.
And so let me get to that.
Set it up such that you could opt out of your court because you think that the marginal cost of doing business is going to make you money by them giving you the 1/3. I mean, that's the question.
Right. So the obligation to fund is identified in 81033 and 8104, and I'll explain. Council used the phrase actually, quote, housed. The statute actually uses the phrase operates within and incurred in. The court operates within its district, within Oak Park. It operates and incurs costs as a result of the entire district in not only Oak Park, but Pleasant Ridge and Huntington Woods.
What does in the district mean?
Pardon?
In that district.
In that
appears
district?
In 3 different sections.
It is.
Okay, what does that mean?
That means the constituent political subdivisions that make up the 45th district by
So it means
statute.
45th district.
That is correct.
It doesn't mean the political boundaries
That is
of
correct.
each of the constituent
Yes.
municipalities. Why didn't the Court of Appeals, that's a much more direct way of resolving this.
Well, I should say this. What council is trying to read into 8103 and 8104 is the phrase sits in. This legislature did not use the phrase sits in those provisions. It talked about operating within and incurred in the district. Therefore, they have a funding obligation. The sits in language is used in 8251 and in 8261.
Didn't that just occur when was 45 district created by the legislature?
Effective 2012.
But it had pre-existed that, right?
The 45B had pre-existed before that.
45B, okay, 45B was the same.
It was made up of the same political subdivisions. That is correct.
8103 strikes me as a definitional section.
Yes.
It seems to me, though, that you're trying to make it an appropriations section.
No.
It started out by telling us what a third-class district is.
Yes.
And then you go on and use the language in describing what it is to say, and therefore they owe us.
Yes. And so interestingly, the way this reads is that the obligation is imparted to them by the statute, 8103 and 8104. So then they have an obligation. The question is, how much? To answer that question, this court, through MCR 8201, provides that the obligation is based upon the weighted caseload, and that is what is the obligation of the constituent communities. Right? The caseload identifies the funding obligations of the communities. The 2/3, 1/3 is a distribution revenue sharing, has nothing to do with the funding obligations. That's the key point that's missing.
What's the legal authority for that court rule?
The legal authority for the court rule is, well, aside from the Constitution, allows under Article 6, Section 5 for this court to administer those rules.
Well, I get that. I get the general legal authority, but wasn't there an earlier version of the statute that invited the court to come up with a funding formula that's no longer in existence that's been?
The one that was ousted in '70.
Well, the current operation, and this actually shows the uniqueness of this case, is that this is the only district court of the third class with multiple political subdivisions that does not have an MOU in place. So this is a unique case, and that the current rule in place, though, is...
Are you certain of that fact?
I am not certain.
Because there's 17 of these across the state. I'm aware that we have only 4 MOUs in place. Are you?
Yeah, there are many more than 4, and in fact, the court's desire is indeed to have an MOU. This particular issue is somewhat of a stumbling block to get to concurrence in that regard.
In your view, is there any difference between an appropriation and revenue sharing?
Absolutely.
So the title of 8379 says fines and costs appropriation. It doesn't say fines and costs revenue sharing.
Right, that is an obligation of the court to have those funds on the 2/3, 1/3 to be distributed back to the constituent communities.
You want us to interpret that entire section, though, as a revenue sharing section, that this is how the court shall be funded?
Correct.
And that the title says appropriation.
Well, that's an expenditure by the court. The appropriation language under 8271 requires that the governing bodies of the political subdivisions appropriate the monies that are obligated.
Thank you.
So I see my light is on. Thank you.
That's why I said thank you.
Mr. Webster comes before you and tells you there's no funding involved. Let me read you from page 17 of Mr. Webster's supplemental brief. As a preliminary matter, appellants do fund the 45th District Court through 8379 revenue sharing. Thus, Oak Park does not entirely fund the 45th District Court, and it never has. Check out what he just said to you. Mr. Chief Justice, you've got the 2 statutes involved incorrectly. I just want you to know. 8103 and 8104 do not use the word district. They use the word political subdivision, which is why it is, in fact, different. That's why the Court of Appeal. Right. Justice Zara, your point is exactly correct. The statute that they're relying on is an appropriation statute. Think about what's not there. What's not there is a proportionality. There's nothing that says what we pay, what my clients will pay. So in essence, what we're looking at is two parties claiming impecunity here, and what they're really looking for is a bonanza.
Well,
what they're looking for.
Counsel, I just have a question.
Sure.
I wasn't going to ask anything, but then since you used the word bonanza, I just can't resist. I mean, who can't resist when you say bonanza? But going with your premise, I find it hard to see how this is a bonanza. If anything, if I were to, and help me to see if my thinking is wrong, because that's what we're here for.
Okay.
If anything, what I see here, when I follow your argument, and have been following your argument very closely, it seems to me that it puts the township that has the court at a disadvantage. It doesn't seem like, if I were to follow your argument, it would seem to me that there's a disincentive for having a court within your community.
No, the fact is that Oak Park wanted this. Oak Park is the entity that in 1974 sent around a proposed resolution for my clients to enter into. Oak Park wanted to house the district court. What happened is, by 1983, 8 years later, there were some remands from the circuit court that no longer made it the moneymaker that it was. But understand this, if Oak Park, if you were listening to what Mr. Hampton had to say, what Mr. Hampton is suggesting is they not only get to 2/3 of every ticket, but they get to come under a court rule. They get to come under a court rule and demand that we pay some unspecified amount under a court rule. Now, the court rule itself, to think about this, in terms of constitutionality, particularly in light of Article 6, Section 5 and Article 6, Section 4, Can a court rule dictate how a district court is to be funded? My suggestion to you is it can't, but that's what Mr. Hampton has proposed. That's what the defendants have proposed in their position. And the fact is, Justice Zara, the fact that there is no apportionment in this appropriation statute is, in fact, highly significant, because if the legislature is going to pass a statute that trumps a across-the-board rule, that is, my clients have no obligation to fund a district court outside their jurisdiction, if the legislature is going to pass a statute that makes that general rule inoperative in every single case, my suggestion to you is that the legislature would, in fact, provide a proportion.
And my
they
suggestion
didn't.
to you is, we're at an end.
I have one last question. It seems to me the opportune time for the MOU was somewhere around 1974, when Oak Park still had some leverage. And so my question is, now that they're in financial distress and not happy with the current state of affairs, do they have the ability to close the district court, to say we're no longer going to host the district court in this district? Thank you very much.
I
Just close it to
assume,
the
I
other
could,
Or
municipalities?
just close it completely.
Close it
To just say, we're, just like they're doing, they're kind of washing their hands of the whole affair, saying,
I
you
think
have the court, can they do
We
the same
waive, we
thing?
waive the
Goodbye.
the court.
Yeah.
I believe, since the district court is in fact a creature of statute, that I don't believe they could do that.
Well, the court itself is, but is the building a creature of statute? And is all of the things that the city has to pay? I'm just wondering if they don't have some leverage, by asserting the same rights your clients are asserting.
To waive it.
Then might cause everyone to get in the room and come up
Yes,
with
and then I assume all of the participating governmental entities would have to go to the legislature and get a new district court. That
Or
would
while
be
they're
the
in that
solution.
room together, they might come up with.
And you know, the solution would also be, if Oak Park is going to insist that we pay both two-thirds and some unspecified amount under 8271, then I guess our position would be that we have to go to the Michigan legislature, and we have to get out of a deal that's been foisted on us, because when my clients signed up for this, my clients signed up for a deal in which their obligation to the court was two-thirds, one-third. That's what my clients signed up for in December of 1974.
But wasn't the
Two-thirds,
spirit,
one-third.
I get that, but wasn't the spirit of it that they were going to be participants within the operation of the court? Like, I understand what you're saying, but isn't the idea that, the court is servicing them? Like, doesn't this court not service the residents that you represent? So
Yes, they do.
it does. So, but ultimately, don't we have to look to what the spirit of the agreement is? That ultimately,
No,
you are
what we
there to
have to look
service
at
people
is,
from other
what
communities.
we have to look at is the funding scheme that the Michigan legislature established. That's why, if Oak Park entered into a bad deal on this, if they asked for this and they got a bad deal, we still look not to the bottom line, we look to what the legislature set up, and what the legislature said.
Thank you very much.
You're relying too much on what we've said before. Now we like vibe and spirit. You missed a memo.
Yeah,
You missed a memo.
you have a real fetish with the statutory.